Hi everyone, thank you for watching Hamara Kanun. Today is 8th March 2016 and we're celebrating International Women's Day. The sad reality in India is that it looks like a place which was known for calling or treating women as Shakti is a place where we are often found discussing the status of women being reduced to that of an Abla Nari. So the discussion today is going to concentrate or look at and provide an overview on the Protection of Women Against Domestic Violence Act 2005. Now, before we get into the nitty-gritties of the Act, let's pose ourselves a bigger question. We all know that in India, violence against women is widespread. But I want to draw your attention to two key statistics. There are several statistics, but let's look at two of them. The National Crime Records Bureau of India has reported that every 3 minutes, there is a report of violence of one kind or the other against a woman in India. And every 6 hours, one woman is found dead, either because she was beaten or raped or burnt. Now, with those statistics in mind and knowing that domestic violence is indeed a sad reality in India, let me take you in the period of next 10 to 15 minutes over some of the main provisions of the Protection of Women Against Domestic Violence Act. First of all, let's step back and ask, what does this Act do? I mean, in the Indian Penal Code of India, we already had several provisions that deal with violence of one kind or the other. But for the first time, the central government came out with the Domestic Violence Act, which is an overview, a kind of a broad legislation that protects women from violence, not just physical violence, but sexual violence, economic violence, verbal violence, or emotional violence. So for the first time, the concept of violence was, interpreted in the broadest sense possible and brought under the aegis of this particular act. The biggest criticism, and I am mindful that I'm bringing this rather earlier in this video, the main criticism against this act is that it is protection of women against domestic violence. So people say, why can't it be men who could be at the receiving end? And that's a fair criticism. But the sad reality in India is that the rate of violence against women is much, much more than that against men. And therefore, it is not to say that there is not domestic violence happening against men. It is not to say that often and sometimes women have been seen or reported to misuse this law against the male. All that is also a sad reality. But for the purposes of this video, let's try and focus on what's best about this act, that it is a good attempt by the central government to provide a quick and speedy resolution to women who are suffering violence of one sort or the other. Now, under this act, as I said, various violence is covered. So if your husband or a person you've been in a domestic relationship with, now, this is important to note because you could just be in a living relationship with a person and you would still be given the protection under Domestic Violence Act. So if you are in a domestic relationship of any kind, the person uses wrong words against you, does not give you enough money to run the household, threatens you in any manner whatsoever, slaps you, beats you, pulls you, shoves you, any and all of this is covered under the ambit of the Act. So the next question is, fine, there is some sort of a violence happening against you. What do you do next? Under the Act, there has been a provision for appointment of someone called protection officer. These protection officers were appointed because at the level of villages, it was reported that even when women realize that they are at the suffering end of violence, either from their husband or another male member in the family, or for that matter, even again through a female member in the family, they don't know what next steps to do. So it is a job of the protection officer who is appointed at these local levels to tell you how to fill an application and how to make use of the Act and use legal remedies. So you can either go through a protection officer, or if you're well aware of your rights, which I hope you are through this video, you can directly apply to Judicial Magistrate First Class, or a Judicial Magistrate of the First Class who has jurisdiction of your matter, or in metropolitan areas, what we have someone called a Metropolitan Magistrate. So which Judicial Magistrate First Class or Metropolitan Magistrate would have the jurisdiction in your case, you may ask? Three things will be looked into. If you are the aggrieved person and wherever you reside or carry your business or are employed, you can be residing temporarily or permanently, you can file a matter before that judge. Or where the other person, that is a person who has actually caused this violence against you, wherever he is residing, either temporarily or permanently, is carrying out his or her business, or is employed, you can also file a matter there. or where the cause of action has arisen. So two of you are living in two different cities or are carrying out businesses in two different cities, but he used violence against you in a third city. Even the judicial magistrate first class or the metropolitan magistrate of that third city would have jurisdiction. Now, there is a particular application format with particulars that you have to mention, which are provided. It's very easily available. It's part of the Domestic Violence Act. Just a basic Google search and you can come up with that form. You just need to fill it and send it to the court. Now, here is the main and interesting thing. Most times you would think the court wouldn't act. Under this act, the courts are required to fix a date of hearing within 3 days of receipt of your application. Moreover, the court is also required to dispose the application within 60 days of hearing of the order. If one of the parties is dissatisfied, since we are talking about time frame, either you or the other person can file an appeal which will go to the Court of Sessions within 30 days of receiving a notice of any order under this act, whichever is later. Now, what are the reliefs that you can claim under this act, you may ask? There are 5 broad types of reliefs, and just mentioning them will give you an idea that it's not really just one kind of relief. There are several kinds of reliefs that you can ask for under this act. Most importantly, you can ask for compensatory relief. You can ask for residence relief. So, for example, if your husband has thrown you out of his place or is not admitting you to the house, you have a right to reside in the matrimonial house. So, right to residence. If your husband is keeping you away from meeting your child, there's something called a custody order, which means that either you will be allowed to meet your child, or if you think that the child is threatened in any way, then the court can also order that the husband will not be allowed to meet the child. Then there are monetary orders that can be given. So, for example, if you think that the husband is not paying you any money, you can actually ask for specific maintenance to be given to you under this act. And finally, you can just ask for any sort of compensation for physical, mental, or other kinds of violence that have been caused to you. Now, the most important and distinct feature of this act is that just by your application, if the court is convinced that there is a prima facie case that's made out, then the court can give an ex parte order. That means in cases of urgent emergency, even without hearing the husband or without hearing the person who you are alleging has caused this violence, the court can come up with an order in your favor. Most importantly, the court can also come up with interim orders. So, for example, the court is not going to look into, because time is of essence, if the court thinks that a final resolution the matter cannot be brought forth, but there is something in the interim that could be done to secure your rights or to protect you, the court can pass an interim order. And this can be done on the basis of an affidavit filed by you. So, you know that in courts, what we look at is evidence. Just your affidavit before the court that this is happening will suffice. However, in most cases, the court, if it has access to, would also ask for a report to be submitted by the protection officer. So if you are a woman who is in an area where you don't have access to information, find out who your local protection officer is. He or she will have all this requisite information and will facilitate that you go to the court at the earliest. Now, these are some of the broad finer points. All this is available on several websites and informations. There are several case laws we can discuss, but through this overview, I hope that you understand that there is a provision, there is a right that you can use if there is any violence against you of any manner, and you in India today, under the Domestic Violence Act, get a quick fix to your problem, a quick resolution, or at least a protection order that protects you so that there is no long-term damage done or carried out against you. I'm Avani Bansal at Harvard Law School. Thank you so much for watching Hamara Kanun. We'll be back next week with another video discussing another important legislation that may impact the lives of you or many. If you like the video, please share it on social media. It is my attempt that the awareness about most important laws in India should reach out to the common man and women, to everybody out there in the most simple and accessible way. Thank you so much.